This matter has become infectious.
13.
Minute.
1-3.
On 3.
Is submitted by Mr. D.A. Kayum that as per instructions received, the matter has become infructuous. Petitioner does not wish to press the petition any further. Accordingly, same stands dismissed as not pressed, and interim orders, if any, stands vacated. Anyone further respondents? All right, disposed.
Obliged.
Yes.
May it please your lordship, my lord. My lord, I beg to mention item numbers 35 and 36, my lord. My lord, in 36, I require to file the affidavit, my lord. So 4 weeks time, I am paying, my lord, before your lordship.
You're for the petitioner.
I am for the respondents 2 to 10.
Have you taken?
I have
consent?
taken the consent of the, my lord, other side. He is the counsel.
Mr. P.K. Das, submits that requires further time for filing affidavit in rejoinder. You want to file affidavit in rejoinder
Yes, my lord, in the second 36.
in item 36. Therefore, prays for 4 weeks' time. He submits that consent of the petitioner has already been obtained. Accordingly, matter will be listed after 4 weeks. Since item 35 is also connected, let both matters be listed after 4.
Lordship, kindly fix a date, Lordship.
Give a date after 4 weeks.
Yes.
May I please, your lord? Lordship, back to mention item number 7, your lord. Arguing counsel, Mr. Ayush Laskar is out of station, your lordship, due to medical reason.
2017 matter.
Yes, your lordship. Short date may be given, your lordship.
You wait. We'll see. Wait, there are so many councils. There are about 5 or 6 councils. Only one is away. What happened to the others?
Actually, the matter was, the brief was taken by Ayush Laskar only few days. I think 2 or 3 days he was,
How do you know?
he telephonically instructed me.
Then if after going through the brief, he felt ill.
No, what happened actually,
You wait, we'll call up the matter. Hear you.
May I please, your lordship? I beg to mention item number 19. In this matter, my lord, will file affidavit in reply in the instant case, my lord.
Item 19,
19, my lord.
and the request of Mr. A. Bhattacharya. Matter stands adjourned for 2 weeks, enabling petitioner to file their reply affidavit in the matter, list after 2 weeks.
I have like, my lord.
May I please, your lordship? My lord, item number 12. We are supposed to file affidavit in this case, lordship. Affidavit in opposition, lordship. But we could not contact the parties since long, lordship. In matter is of 17. And since 17, we are to suppose file the affidavit in opposition. Party is not coming, lordship.
So we dismiss it.
Lordship may close the matter.
Item 12.
12.
It is submitted by the learned counsel to the petitioner that on instructions that the petitioner is not interested to pursue the writ petition. And therefore he submits that on instructions that the writ petition be closed as not pressed. Accordingly, the writ petition is dismissed as not pressed. Interim orders, if any, stands vacated.
Interim order was there that time.
I'll stand vacated.
Obliged.
May I please, your lordship? Lordship, I beg to mention item number 14 for adjournment. As my senior, Mr. S.K. Medhi is out of station.
Who is for the, yes, Mr. Counsel.
Maybe fix a date, my lord.
On 25th September,
Yeah, we can't give you a date like that. What is the matter about?
My lord, punishment for CRP personnel, my lord. Disciplinary proceeding and punishment CRP personnel.
Termination.
Termination, not there, but other punishment are there.
All right. At the request of Mr.
K.K. Medhi.
A.K. Medhi, matter stands adjourned for 3 weeks. Mr. S. Chauhan, learned counsel for the petitioner, does not object to the prayer made by the learned counsel for respondents. List after 3 weeks. Give a date after 3 weeks for admission hearing.
Your Lordship, with the consent of other side, I beg to mention item number 23,
Item
And-
number
23, kindly adjourn for the day.
23.
Yes,
You are making a mention on whose behalf?
P.K. Rai Chaudhary,
Why?
senior counsel is out of station.
Item 23 stands passed over at the request of Mr. Swain to learned counsel for the petition.
Right, please, Your Lordship. I beg to mention item number 3. My senior counsel is out of station.
Wait. Item 3,
Item 3.
just wait. Yes, Mr. Bhagwati.
Also, if the matter is pertaining to compassionate appointment, Lordship. There was
Somebody
a
was to file an affidavit.
Lordship.
What happened?
Your Lordship, instructions are not yet received, Your Lordship. We have written to them. If Your Lordship gives me, list the matter on Friday, I'll get the instructions. Your Lordship.
What is the issue here, Mr. Bhagwati?
Lordship, issue is here, Lordship, there was a select list, 3 persons were selected by the DLC, Lordship.
This is the compassionate appointment.
Lordship. 3 persons were selected, Lordship, I was left out, Lordship. They said, according to the list, Lordship, they said that it was according to merit. So, in compassionate appointment,
Where is the DLC
Lordship,
minutes?
page, Lordship,
27.
Lordship. Lordship may come to page 28, Lordship. Bottom.
You're for grade 3 or 4.
Lordship, they could have given me anything, Lordship, but they used to give me grade 3, Lordship. My name is at serial number 3, Lordship. Unisa Rahman.
Your name was forwarded.
Lordship, it was forwarded,
Ah.
but the SLC rejected it, Lordship.
Where is the SLC minutes?
Lordship. In their affidavit, Lordship, they have given, Lordship. Lordship, in their affidavit, Lordship. They have stated that it was rejected, Lordship. Their affidavit is in page 24, Lordship. And another, Lordship, page 14, Lordship.
Page
14, 1-4,
annexure 4.
Lordship.
According to SLC, it is beyond 5%.
Lordship.
Is there any material to show that is not correct?
Lordship, they, when they selected in the DLC, Lordship, they stated that it was according to merit, Lordship. They prepared a list according to merit. But what is merit in compassionate appointment, Lordship?
No. In annexure 4,
Lordship,
they say at the last paragraph,
Lordship,
they say that the DLC recommended candidates for more than 5%.
Lordship. If that is there, Lordship, out of 3 selected, Lordship, by the DLC, 2 were appointed. If they go by this criteria, Lordship, only 1 could have been appointed, Lordship.
Who are these 2?
Lordship, serial number, Lordship, 1 and 2 of my list, Lordship. Page, Lordship, 28 of my eight petition, Lordship. Zakimani Das and Aniruddha Das.
Where is Aniruddha?
Lordship. Aniruddha is Lordship, their affidavit, Lordship, they have said Lordship, executive engineer of irrigation
So,
department.
In the
Lordship,
list,
Page 27.
27 of
Of their affidavit.
their affidavit.
While I was filing it, Lordship, I could not acquire any document, Lordship. Subsequently, they have provided it, Lordship, in their affidavit, irrigation department. Page 27, serial number 4.
And where is Jyotimani?
Lordship, Jyotimani is Lordship, in, I think, page 14, Lordship. Page 15, Lordship. Serial number 2.
So these were appointed, page 27
Lordship.
is appointed pursuant to some court orders.
Court's order was that to consider. I also had that kind of a order, Lordship, to consider my case. That was also to consider my case. But while they prepared the list in BLC, Lordship, they prepared in the order of merit, Lordship.
Where is it mentioned there?
Lordship, page 11, Lordship. Same, there is only, Lordship.
11.
11.
Page 11.
Below, Lordship. Down below. Executive engineer, Guwahati West Division, irrigation, Guwahati. Last line of that para, Lordship. Entry numbered cases for grade 3 in order of merit.
The order of merit perhaps is just to indicate that there was some selection process and
Exactly, Lordship. What
Ah.
selection process, Lordship? High, Lordship, educational qualification, that cannot be taken into consideration, Lordship.
no, correct.
Lordship, therefore, the honorable court directed them to place whether, to see the financial status, Lordship. That is why they were required to file the affidavit. If the financial criteria, they mean to say that. it
Why
was order
don't
of
you
merit.
produce the records
The Lordship,
of the SLC?
I have a preliminary submission. Here the SLC is not made a party. And secondly, he has not challenged that SLC minutes in this particular writ petition. So in my humble submission, my learned friend has to challenge that SLC minutes.
Subsequently, they had provided, Lordship. I could not get it, Lordship.
That is what your Lordship.
You did not provide the minutes, how will you challenge it?
Lordship, subsequently, only I came to know that I was not selected, Lordship. They had filed the affidavit, Lordship. Therein they said that I was rejected.
He has to challenge it, your Lordship. SLC minutes have to be
Even,
challenged.
even if I not select, Lordship.
Why challenge it? Is it not a part of the pleadings?
Lordship, exactly.
Your Lordship, because a new cause of action has arisen in
How?
terms of the SLC minutes.
No,
Your
that is provided by you. You are aware of it.
We are aware of it.
This
but
is
he
not a
has to
case,
challenge it.
this is not a case that this SLC minutes has suddenly cropped up from somewhere. You have filed it.
That is true.
You are aware.
But at the same time, he has to.
No,
challenge
what
it.
is the
If he-
concept of challenge? That's what
if
I
we
want
have
to.
to go by the prayer, your Lordship,
No, prayer is for any other relief.
if your Lordship takes it Your Lordship, then we have to actually get the information also. As per last direction, we have to get the financial status.
You have not got it.
Not, Your Lordship, because the matter was last.
Is the court supposed to keep on waiting, giving you adjournments?
No, Your Lordship, just till Friday.
1 year, it was 1 year, 31/1/2022.
Just till Friday, Your Lordship, I'll get the instruction.
What instructions will you get?
That particular financial position. They saw only from
You
Kamrup
produce the
Metro-
records.
Kamrup Metro office.
You produce the records by which the process of selection had taken place.
Your Lordship, I'll try to produce records. I'll try to produce.
What is the meaning of try to?
If because
You are
it's very
asking for
old-
time.
Because it's a very old record, Your Lordship, that's why.
Is it our
2000
fault that the matter has become old?
2007,
Is it our fault that the matter is before the court? You
I
should have addressed these problems when
I
the
agree.
petitioner had gone there.
agree, Your Lordship.
Then
We have written to them also on 31st itself, 31st January.
if they have not given it, you tell us who is supposed to give, we'll call them.
No, Your Lordship,
Who is supposed to give
just
you
till
that
Friday,
instruction?
Your Lordship, I'll get it, Your Lordship. Just till Friday, I'll get it, Your Lordship. Today is Monday, I'll get it back Friday. If Your Lordship lists on Friday, I'll get it Monday, Your Lordship. I'll get it, Your Lordship.
Yes, Mr.
Lordship may see this order was has been carrying on from 33/10/2018, Lordship. As per the Honorable Court's order, Lordship 31/1/2022. That is reflected, Lordship. This order has been.
What have you stated in your affidavit as to how the selection process was conducted? You don't have the brief also.
No, we have the brief, but the affidavit is missing from the brief, Your Lordship.
Lordship, affidavit was actually filed by the irrigation department, Lordship.
No, who conducted this process? The
DLC,
DLC? No, SLC.
SLC, Your Lordship.
So SLC is headed by Chief Secretary.
Chief Secretary, Your Lordship.
So who
Commissioner is
represents
also
the Chief
there.
Secretary?
In fact, this affidavit was filed by the irrigation department. That's why I don't have it, Your Lordship.
Then why are you volunteering to get instructions by Friday?
With regards to the
How
financial position,
confident, how can you be so confident?
because this financial position was considered by the DLC. And that information would be with the district commissioner's office.
That
Your Lordship.
DLC position has been rejected in the SLC.
Yes, Your Lordship, I agree. But since Your Lordship directed on last occasion to get the financial position of the other two candidates, that's why.
We want to know what, as per your memorandum, there is a process by which you'll undertake the evaluation. So whether you have followed it or not is what we are required to see.
Your Lordship. Your Lordship, then it will take some time to get it from the SLC. If it had been from DC office, yes, I would have. SLC, it will take some time.
What do you mean take some time?
2 weeks time, Your Lordship.
What
maybe
2 weeks
last week.
time? 31/1/22 was the last order.
I agree, Your Lordship. I agree. But after that, the matter was not listed. That's why it went into cold storage, Your Lordship.
Mr. Counsel, don't give these excuses. Don't give these excuses. You are supposed to get instructions. The instructions are not here. I can understand that some other counsel's name is reflected in the last order. You were not aware, but that is not your ground for seeking adjournment. We'll give you 1 week's time. You procure. Mr. Hart, learned counsel for the parties. Mr. So-and-so learned counsel for the government. You're a government counsel
Yes, Your Lordship.
appearing for the government submits that the instruction sought for has not been received. Prays for 2 weeks' time. It is seen that the last order in the matter was on 31/1/2022. The matter pertains to the year 2015. The short question the short instruction which is required from the respondents is to the manner of evaluation of the persons selected for appointment on compassionate ground. Stop. Because of repeated adjournments being sought for by the respondent department, the matter has been delayed. As a matter of last opportunity, the matter stands adjourned for 1 week, enabling the respondents to obtain the required instructions as to the manner of evaluation, as to the procedure adopted for evaluation of the candidates shortlisted for selection on compassionate ground by the SLC. These instructions be furnished before the court by the next date fixed. List on 2020.
20. Obliged, Lord.
Yeah, please, Your Lordship. No, the petitioner was a CRPF cadre, my lord. His posting was at Dhubri, my lord, in the year 2008. At that time, my lord, the assistant commandant referred him, my lord, as Bangladeshi. And my lord, he harassed, he punished several occasions,
Pleadings are complete.
my lord,
Pleadings are complete.
my lord.
In fact, the private respondent number 6 and 7. They are also affidavits are ready. It has been sent for very necessary vetting, Lordship.
You are appearing for 5 and 6.
I am appearing for all now. 6 and 7.
6 and 7.
6 and 7 private respondents, he has been made by name. So affidavits are ready, actually, it has been sent for necessary vetting. Or Lordship may take up the matter after 2 weeks or on the basis of the affidavit filed by the other respondents, matter may be taken up.
2015 matter, you are sending affidavit for vetting now.
And what about the private respondents, they did not receive notice. On receipt of notice, they engaged me as a central government council.
No, but I don't think it's for you to decide, but I don't think you can appear on behalf of 5 and 6 there by name. You are representing the central government.
Lordship.
5 and 6, no doubt, are employees in the central
Yeah,
government,
they're
but
the
they are
em-
appointed by name. They are arrayed by name. Should you
That's true, Lordship.
appear for all of them? That's up to you for you to decide. Heard learned counsel for the parties, this matter pertains to termination.
No, Lordship. Physical harassment. Allegation is that he has been physically harassed.
For relegating the petitioner to lower medical category. Stop. You are still in service.
Yes, my lord.
The respondents, central government has filed their affidavit. However, respondents 6 and 7 who are arrayed by name as parties have not filed their affidavit. Mr. T. Bora, counsel appearing for them, for all the respondents, raised for 2 weeks further time to obtain necessary instructions, to file necessary affidavit in the matter, at least after 2 weeks. We are giving you 2 weeks time.
Lordship. Obliged, Lordship.
After 2 weeks.
Item number 3.
Please, Your Lordship. This is in respect of for compassionate appointment. On last occasion, an additional affidavit was filed on behalf of the petitioner whereby he has stated his economic status as sought from the Honorable High Court in Order 2/1/2023. Basically, Lordship, this petitioner, he is unemployed still now. His application was forwarded from his side in the year 2007. From 2007 till 2015, he did not got any reply. That's why in 2014, he had filed a representation. On the basis of that representation, the respondent authority had given a reply. He was not satisfied with the reply. So he had again, done an RTI. And on the basis of the RTI, as per the order dated 12/3/2018, passed by the Honorable High Court, the respondent authority was supposed to give a list of the breakup which was provided from their side only through their RTI reply regarding grade 3 post that was around 15 number of grade 3 and 7 number of grade 4 post. But that was not provided from their side. And then because of the COVID pandemic, the matter got delayed. And then it finally in the year 2020, 2020 it was listed for the last time, and then it again was listed in 2021, and like this the matter got delayed, Lordship. Now basically now since the matter is
Where is the SLC minutes?
no, my lord, it has not gone to SLC. It was in DLC only. And now, though it was in DLC, the respondent authorities was not able to give a proper reply because they have said that they would not trace out.
DLC rejected your case.
No, it is not rejected also. My representation could not be traced out from the respondent authorities. They have given a reply through letters.
Is there any official correspondence to show that your case has been forwarded?
Yes, my lord. Let me page to page number. This annexure. Page number 35, my lord. And that is the reply that has been given from the your letter number by the additional deputy commissioner, the correspondence that has been made from the additional deputy commissioner to the state public information officer. Here, my lord, in para number 4A, 4Z and 4D, dated 13/4/2015, respondent had replied that the RT application made by the petitioner wherein stated that the prior petition of the petitioner could not be traced out, while substantially creates a doubt that the application was not sent to the DLC. That was their reply. Now, the petitioner had sent that representation. Now, going to his representation, he had made in the year 2007 itself. That is in page number 8/10/2007, page number 29, my lord. He had done an RTI where he had sought information dated page number 29. Submit application for complaint.
31.
31, my lord. Beg your pardon. 31. Application stating remonstrance regarding non-appointment compassionate ground. He writes, your lordship, sir, with due regard, I beg to state that my father, late Gogon Chandra Bora, resident of Porpotia Bezar Suburi, was an employee to the office of the deputy commissioner Tezpur, and he died in the month of July 2007 before completion of his service period. Sir, I, Sri Hirokjyoti Bora, is the son of late so. As per rules, I, on October 2007, applied for compassionate appointment of government, but till today have not got any reply. I therefore earnestly pray for your good self to kindly peruse the matter and take appropriate decisions. That was the correspondence that was made from the petitioner side to the Honorable Commissioner, North Assam Circle, Tezpur, in dated 14 to 2015. That is Annexure F, page number 31.
Your case was rejected. Your case was rejected.
But there was no official, there was no such order. Yes, that is why I sought the information, and then later-
Where is that RTI information?
that is in page number.
RTI query?
RTI query was Annexure Z 33, page number 33, dated 23 to 2015.
You did not ask for the order. Did you ask for the order? Minutes, you did not ask for it.
In paragraph number 4E, the petitioner has sought for furnish the certified photocopies of the documents and particulars, how many candidates' names were approved by the SLC. Meeting for appointment on compassionate ground in grade 3 and grade 4 was during 2007 to 2015.
You did not get it.
No, we got the reply, ma'am. We got the reply, and the reply, they have stated that there were altogether 29 numbers of grade 3 and 25 numbers of grade 4 applications, which were submitted before the Deputy Commissioner.
Come to page number 35,
Yes, ma'am. Page number 35.
serial number 4A.
4A, ma'am.
Your case was shown to be rejected. He wrote
His
you-
prayer petition also not traced out, ma'am.
Huh?
The last word, 4A,
Huh.
his prayer petition also not traced out. His petition could not be traced out.
May not be, but your case was considered and found rejected because of this.
Yes, my lord.
Then
No, my prayer was that since I had sought the RTI reply, and since my petition could not be traced out, I had
you go and appeal before the RTI authority, appellate authority is there.
my lord,
If the RTI queries are not answered, you have an appellate forum.
my lord. My lord, since the discussion was there before the honorable.
What do you want?
My lord, that since these posts were already there, and since the honorable court,
So for that, you have to challenge the minutes at least.
my lord.
Your case is that pleaded case is that it was never considered for compassionate appointment, which it does not appear to be correct. There are 15 of your writ petition.
My lord.
The respondent authorities did not consider his case for compassionate appointment.
Since I did not get the communication, my lord,
That's right, but now you've got the RTI reply that you have been rejected.
but my petition could not be traced out, my
What relevance has it got?
my lord. There has to be some speaking order. Or
They
some,
did not say that your petition was not there, therefore you are rejected.
Right.
They say that this is beyond 2 years or something. Where is that reply?
that is page number 35, Annexure I, 4A.
See 35A, 4A,
4A here it says that, but due to
non-availability of post.
non-availability.
It is for you to now gather information and find out whether it is
Yes, my
correct
lord,
or
that
not.
at that period of time they were post. That is the reason, because in 4B they have stated that there are 29 numbers of grade 3 and 25 numbers of grade 4 application at that time, and out of that 15 of grade 3 were recommended and they have been approved, and 7 for grade 4. So what are the remaining posts? What about the remaining at that time? So that is why the Honorable Court had sought instruction from the respondents authorities to at least give that reply regarding that breakup. What happened? It has been stated specifically in order dated 12/3/2018 passed by the Honorable Court. Ma'am.
Lordship, if
And-
I may, Your Lordship, that is not correct, Your Lordship, because the serial number B, it says total 29 numbers of grade 3 and 25 number of grade 4 applications were submitted. It is not the number of posts, as my learned friend is saying. It's the number of applications which are submitted, and 15 posts, 15 numbers of grade 3 and 7 numbers of grade 4 were recommended in the DLC meeting. Point para B says applications, not posts.
There is a communication available here on record. Are you aware of it?
Page number 35, Your Lordship,
No,
there's
no,
a
no.
RTI reply.
Some communication was placed before the court earlier.
Your Lordship, it is not in my brief. Your Lordship, it is not there. And if I may submit, Your Lordship,
First, go through that instruction before you submit anything.
Your Lordship.
What?
It could not be found out. Irrevocably order.
Then?
Your Lordship, if I may submit, Your Lordship, on legal position, Your Lordship, the petitioner's father, he died way back in 2007. And now we are today here in 2023. The basic purpose of any compassionate appointment is to tide over immediate financial hardships with any. Now that if he has survived so long till 2023, the whole intent of compassionate appointment is somewhat diluted.
Where is your application? Do you have that application with you?
My lord. My lord, only the information regarding that he has submitted the application representation in the year 2007 has been stated in 2015 in his representation when he has not got the reply. That is in page number 31, 14 to 2015. Page number 31, my lord. The last para, sir, I, Sri Hirok Jyoti Bora, is the son of late Gagan Chandra Bora. As per rules, I on October 2007 applied for compassionate appointment of government, but till today have not got any reply. I therefore earnestly pray for your good self to kindly pursue the matter and take appropriate decision. He has sent it to the Honorable Commissioner, not Assam Circle Tribunal. There he has stated. So definitely, if he would have submitted an representation, that is the reason why he has stated in this particular second representation. This should be taken as a second representation. But now, since he has not got the reply, he has stated it. He has his signature. He has his signature also.
When did he submit?
8/1/2007, 8th of October 2007. And his father died on 37/2007. He died in Harnett while he was serving as a junior assistant in the office of Deputy Commissioner Sonit.
Page number 29 is the RTI reply when it was submitted.
Here in page number 29 also, that he has sent his representation, they have admitted, the respondent authority, stating that had submitted his application for compassionate appointment on 8/10/2007 to this office. And second point, they have stated, as within the stipulated time period there were no vacant posts, his application could not be considered for appointment. And then later on again, they said that his prayer petition could not be traced out. In fact, they themselves, they have admitted that they had got his representation also. Being dissatisfied with this reply, my lord, he had filed that RTF, since he had come to know that there were some posts at that time during that period from 2007 to 15.
Now tell us what you want.
My lord, if one more chance, if I given to go to DLC, and if I get rejected as well and good, there's no objection on my part. Only thing is that since I have waited, since there was a right that was infringed on me, I had exercised my right, and I should be given one chance. Now, since they themselves, they are having two deviating stands. Once they say that they have already admitted it and that he has submitted, now they say that his petition could not be traced up.
Page 31 is addressed by whom? By you? Or page 30?
Page 30. Page 30 is the SME's version of the
Additional Deputy Commissioner.
SME's version. We have translated in page number 20.
I know, but what is this?
Oh, my lord. This is regarding the application seeking information dated by the Bora. This was correspondence from the additional deputy commissioner to the
No, I
SPI.
was referring to page 30, 30 and 31.
30. Oh dear, that is the SME's annexure, my lord, page number 30.
31.
31, yeah. That is the second representation which he had
Before?
before the honorable commissioner. He has filed it.
Which commissioner?
The honorable commissioner, North Assam Circle, my lord. আয়ুক্ত মহোদয় উত্তর অসম মন্ডল তেজপুর। That is the honorable commissioner, North Assam Circle, honorable commissioner of
Third learned counsels for the parties. This writ petition has been filed by the petitioner who is aggrieved by non-consideration of his application for seeking compassionate appointment. Stop. The father of the petitioner was serving as a junior assistant in the office of the Deputy Commissioner Sunitpur, Tezpur, and he died in harness on 3007/2007. Petitioner submitted his application on 8/10/2007 in the office of the Deputy Commissioner Sunitpur, Tezpur, praying for appointment on compassionate ground. However, said that no information was forthcoming from the said office. Stop. Petitioner thereafter filed applications under Right to Information Act 2005. Stop. In response to his application under RTI, the respondent authorities by communication dated 5/2/2015 submitted their reply. In the said reply, which is enclosed, the said reply, it was mentioned that the case of the petitioner would not be considered due to non-availability of posts during the period of 2 years from the date of death of his father, and therefore his proposal could not be recommended by the DMC. In terms of the judgment and order passed by this
May I please, my lord? My lord, this matter was pertaining to apprenticeship which I was going through the railway authority, my lord. And in the meanwhile, after certain verification, they found out that my apprenticeship will not be continued. Page number 39, annexure 13 is this particular notice that I am challenging.
Yes.
My lord, it was notice regarding termination of apprenticeship training and agreement and recovery of 3 months taken to bring found ineligibility for recruitment and training as an apprentice. Now, my lord, what I'm trying to emphasize on the main issue when this writ petition was filed, my lord, there was my examination that was to be conducted. And since my examination was there, that's why, my lord, this honorable court was pleased to pass an order, which I was allowed to give my examination. And whether I can take up the results or not will be the outcome of the writ petition. Now, before going to that, my lord, how they have come to the finding that I am not ineligible, as they have mentioned in the affidavit which they have filed, that is as per the Apprenticeship Act. My lord, may please come to page number 27, my lord. This is an application. This is the engagement of pass out ITI candidates as Act apprenticeship in NF Railway Mechanical Workshop Dibrugarh, the Apprenticeship Act. My lord, here they have specifically mentioned what are the conditions that are required for being the apprentice. In the conditions, my lord, point number 5, page number 27, my lord.
Yes.
Point number 5, the conditions.
Yes.
If not suitable, OBC, ex-servicemen candidates are available. Trades will be filled up by unreserved candidate. My lord, these are certain conditions where I'm trying to reflect that in all these conditions, there is no mention that if at all I have undergone any apprenticeship in the same trade, I will be rejected or my application will be rejected on that particular ground. Similarly, if I keep on continuing, my lord, the qualification which is required in page number 28, page number 9, the qualifications required is also fulfilled by me. Training period is there, stipend is there, how to apply. And slowly, if I go to the other pages, the mode of selection, my lord, that is in page number 30. Before that, my lord, convincing in any manner will be disqualification of the candidate. Page number 30, my lord. These are the modes on which my apprenticeship application may be disqualified.
Yes.
The only condition which have been mentioned in this particular application says that application received after closing date of time will not be entertained. Candidates should send their application sufficiently in advance before the closing date. My lord, point number 18 says railway administration will not be responsible for any postal delay or wrong delivery at any stage. My lord, these are the two conditions on which it says that there will be disqualification of my candidature. Mode of selections also says how it's going to do, but says nothing about what is the ground that they have mentioned in their notice, which I'm challenging. My lord, after this application was given, my lord, there is a letter that I have received from the office of the Chief Workshop Manager, Mechanical Workshop Dibrugarh, page number 32, my lord. 32, my lord, I'm trying to show the series of events, how I was selected and how the railway authority have, by following the due procedure, has accepted me in their organization as an apprenticeship. My lord, this particular says that call letter for documents verification. My lord, I'm trying to emphasize this on this particular point. Call letter for document verification and medical examination of passed out apprenticeship ITI candidates declared successful in screening for engagement as Act apprenticeship in NF Railway Mechanical Workshop Dibrugarh under Apprenticeship Act. My lord, there is a word used called screening, and the word further has been clarified. After screening, you are found suitable. What screening, my lord? The screening of the documents which has been sent by me in my application. Now, one point to be raised, my lord, the documents which I have sent also is accompanied with the
trade that I have gone under the Maruti Suzuki in the same trade, which is the ground that has been raised by them. My lord, after proper screening, they found me suitable, and for engagement, they have called me. You are therefore advised to attend the NF Railway Medical Workshop Dibrugarh on 2915 for document verification and medical examination. My lord, this is the way.
Were you working in the private company?
No, my lord. I was just as an apprentice, my lord. I have completed my ITI. After completion of my ITI, I was trying to get job and apprenticeship to gain my experience, my lord. These are the few certificates which I
So
have.
the only ground for rejection is that you underwent training earlier.
Yes, my lord. But one thing to be noted, my lord, after entire process has been completed after the verification of documents and my medical examination, I was
What is
appointed.
there stand in the affidavit?
My lord, this stand in the affidavit has been taken that since the rule of the Apprenticeship Act doesn't allow me to go to take apprenticeship in the same trade. That's the reason why they.
Where have they stated?
No. My lord, may come to page number 3.
Page 3.
This is an explanation given, my lord, page 2, point number 5. Page 2, point number 5. It is in continuation of page 3 that says that with regard to the statement made in paragraph number 6 in the writ petition, the deponents to state that Mr. Deepak for apprenticeship training was based on percentage of matriculation.
Who is Deepak?
Deepak is the petitioner, my lord. It has nothing to do with NCVT certificate as per procedure laid down in the apprenticeship rule. Concerned regional director has also right to reject accept application of trade apprentices. My lord, this is the rule they are talking about, and by following this procedure, they have rejected my application. Now, one of the most important and vital question that arises, my lord,
Yes.
one thing's to be noted, my lord, when my apprenticeship was rejected, I have completed 11 months of my apprenticeship. And my lord, this was for the period of 1 year, that is of 12 months. At the time when I am supposed to give my examination, they came with the rules and said that it cannot be accepted. And I'm not supposed to go with the undergoing examination that was to be held there. My ground of challenges, my lord, this particular notice which says that I cannot appear and there is a termination of my apprenticeship, but whether at that stage they can do or not. In fact, the procedure which I have just laid down before your lordship, the procedure which has been followed by them, itself says that there was proper verifications of documents and as well as there was proper medical examination. Page number 9 of my writ petition, page number 33 of my writ petition, my lord. Annexure 9 is a letter given to the principal of STC/NBQ NF Railway from the office of the Chief Workshop Manager NF Railway Dibrugarh. It says, my lord, the following selected candidate of the Act apprenticeship is hereby directed to report at your end on 1/10/15 for undergoing apprenticeship training and advised to perform his training with uniform prescribed so and so. My lord, the main thing why I'm trying to refer here is that after completion of entire verification which has been conducted by the Railway Authority, only then I was selected and was given direction to appear before the concerned principal. And accordingly, I appeared and I had continued my apprenticeship for 11 months. And the notice on the verge of completion of my examination says that my apprenticeship has been cancelled and there was a direction to refund the 3 months stipend that I have received. So, my lord, my result is still hanging. I'm not able to take back my results because there was a direction from this honorable court. It will be the outcome of the writ petition only.
Have you referred any orders of this court?
My lord, the order of this court was.
No. Any
Yes.
other judgments or order you have referred?
My lord, there is a direction which is mentioned in page number 14 and to 17, my lord. This
No.
particular
To page 48.
Yes, my lord, 48.
What is the status of this petition?
My lord, I'm unaware about it, but at the same time, my lord, this pertains to different subjects, my lord. My subject was, by subject, I mean to the issue which was raised, my lord,
But pertaining to the same examination?
pertaining to same examination.
Yes, Mr.
Lordship,
Yes,
sorry,
who's appearing?
sorry,
Yes.
Lordship. Learned Council, the Railway Standing Council, Deepak Kumar De Lordship, call me over phone, Lordship, due to some personal difficulty, couldn't appear. Lordship.
After you have allowed the council to argue the matter,
Lordship, just call me, I ran Lordship.
is there only one railway council in the matter?
Lordship, he called me over phone, Lordship.
No, no.
Kindly,
What
play
is
record.
this? You have allowed the council to argue the matter?
Lordship, I ran Lordship, he called me over phone, Lordship, I ran.
No. This kind of histrionics.
Sorry,
will not
Lordship.
apply
I think
here.
so.
Do you have a senior standing council of the railways?
No, Lordship, my colleague, Lordship, I am not senior standing council.
Mr. Dotto, you are appearing for whom?
After dismissal for default, after dismiss for default of the writ petition, this the case was entrusted upon me, my lord.
Huh?
But entrusted upon me by the CGC office, my lord. Now I have filed this affidavit in opposition.
Yes.
That is why he wants to appear in this case, my lord. I have no objection, my
Who filed this affidavit?
lord. Deepak Day, my lord.
You are also a railway council.
Not, but we can do on behalf of the railway also. my lord.
What are the rules on the basis of which his case was rejected?
It is stated, my lord, first of all, employment notice, my lord, at page 27, my
27 or?
27 of writ petition.
Yes.
This is
Yes.
application one, my lord. Application are invited in the prescribed format from the candidate fulfilling
What is the
that
condition of the act and the rules?
for imparting training, my lord.
Do you have a copy of the act and the rules?
Yes, my lord. My lord, this is filed with the railway, my lord. Affidavit in opposition, my lord.
Mechanical workshop, apprenticeship act. 61.
Continuation page 54, my lord. Para 4, my lord.
Para?
Para 4, my lord.
Yes.
That with regards to the statement made in paragraph 5 of the writ petition, the deponent begs to state that the purpose of apprentice training to provide skilled manpower to industry, not to provide job in concerned establishment. As per Apprentice Act 1961, item number 22, it shall not
Do
be.
you show us the provision where it says that because he underwent some apprenticeship, he is not allowed to take part in the apprenticeship offered by under NF Railway? Where is that part of the rules?
My lord, there is an impugn letter, it is.
Not impugn letter. Your affidavit says it is as per the rules.
Yes. It is a rule 14 of 1992 rules, appendix C rules, my lord.
Page number? Is it a part of the pleadings?
Yeah, my lord,
Yes, rule 14.
here 61, page 61, and,
61, 62.
page 61 of my PDP.
All right. Record and returns. What is the rule?
Rule says, my lord, seven eight. 1978. It shall not be obligatory on the part of the employer to offer any employment to the apprentice on
We are
completion.
not
of-
on that. He has been,
My lord, it
he has
is
not been allowed to
that-
appear.
that the petitioner already obtained apprenticeship certificate course in Maruti Udyog. from
Where is that
Maruti Udyog.
communication you are
Filter trade.
challenging? Where is that communication?
My lord, may page number 39, my lord,
39.
39.
Now, this fact that he has already he underwent some apprenticeship. In your affidavit, you say this is entirely as per the rules. Now, which portion of the rules indicate that? That is what we want to find out.
He cannot, is not entitled to go for apprenticeship certificate course.
On what
Twice.
basis are you saying it?
Yeah. Page 64, my lord. Page 64.
Yes.
This is letter from the Ministry of Development from Kolkata, my lord, to 6 workshop manager, carriage and wagon workshop, and a railway in Dibrugarh. In pursuance of your letter referred above, please find enclosed 2 copies of contract proposal of 23 numbers appendices are forwarded herewith after registration. The remaining 4 numbers appendices of Sri Sasanja contract form are followed efficiency. At Mala serial number 4, Roman 4.
Hmm.
Deepak, son of Jagdish Chandra, pet filter. And next, my lord, the above serial number 1 to mark sheet certificate person, and serial number 3 and serial number 4, my lord. Next, my lord, as well as serial number 4 is already issued state NSC certificate. So return the 4 number contact form for rectification. It is from Director of Training, Regional Director. And next page, my lord. Email communication.
Please come to page 56. Running page 56.
Yeah.
Paragraph 8.
8. The applicant has already undergone apprentice training
at Maruti Suzuki for 1 year and conferred with National Apprentice Certificate by NCVT. So the applicant was not eligible for apprentice training.
On what
Again,
basis is the statement being
it
made?
is a statement from the later dated 65 mile at page 65,
No, the paragraph doesn't say so.
65 mile. It is from the
You read the entire paragraph, Mr. Dotto.
yes, as provided, it's a Rule 7(4)B of Apprentice Act 1961. For failure on the part of the apprentice or his guardian shall refund to the employer as cost of training.
What is the
Such a-
result? What is the result of the examination?
Pursuant to that, that communication, my lord, 65 at page 65, my lord.
No, there is an interim order allowing him to sit in the exam. What is the results?
My lord, already when the petition was filed, already uh, training examination was over.
When was it over?
To be held April 2017, my lord.
Heart Learned Council for the parties.
April
Mr. A.
2017.
Dotto, Learned CGC, appears for the railways. The grievance of the petitioner is that he had applied for undergoing apprenticeship training under the NF Railways. Stop. He was allowed to undergo training for about 3 months.
No, my lord. For 12 months, 1 year.
1 year. my lord.
How many months did you undergo?
11 months. My lord.
You had undergone 11 months.
11 months I have undergone.
He had undergone 11 months of training. Subsequently, he was terminated from the said training on the ground that he had earlier undergone apprenticeship training in a private concern, namely Maruti Suzuki. Stop. The stand of the railways is that a person cannot be allowed to undergo apprenticeship training twice. Stop. Being agreed, the petitioner had approached his court, challenging his termination. This court, while
It's a withheld.
issuing notice,
Order date is
Yeah,
6/4/17.
the line लिखो. The petitioners approached this court and submits that he had undergone 11 months of training, and after completion of the training, he is required to appear for the examination or apprenticeship test, which was scheduled to commence from 18th April 2017. Stop. This court, while issuing notice of motion by order dated 6/4/2017, permitted the petitioner to appear in the said examination. But the results were directed not to be declared until further orders. The said interim order was extended from time to time. Para, it is submitted by learned counsel for the petitioner that he has appeared in the examination.
Yes, my lord, I have.
Pursuant to the orders of the court, he has appeared in the examination. However, the results are withheld. Until date, he does not know his position. Stop. Para, Mr. Dr. Learned Counsel appearing for the NF Railway has referred to the affidavit stated to have been filed, affidavit filed by the railway authorities. Stop. The perusal of the affidavit reveals that the termination of the petitioner was stated to have been made following the procedures prescribed under the, what is that act? NF Railway Apprenticeship Act. What is the name of the act? So and so act and the rules made thereunder. Stop. There is a categorical averment in the affidavit that the petitioner did not fulfill the eligibility criteria. Stop. It was also averred that since the petitioner had undergone training at Maruti Suzuki for 1 year and conferred with the National Apprenticeship Certificate by NCVT, the petitioner was not eligible for apprenticeship training again. Stop. However, on a pointed query made by the court, the learned counsel is unable to refer to the specific provisions under the act or under the rules which prohibits candidates from undergoing apprenticeship training if they had earlier undergone the same. Stop. The learned counsel is the railway authorities are directed to place before this court the criteria for selection of candidates for undergoing national apprenticeship training under the NF Railway, and the specific bar which prohibits candidates from undergoing apprenticeship training again if they had earlier completed it. Stop. Mr. Dotto, learned counsel appearing for the railways, is permitted 1 week's further time to place these instructions, place this information before this court. This is the matter of 1 week.
My lord, if any date may be fixed. my lord.
A popular episode later.
Obliged, my lord.
Yes, APDCL.
Yes, my lord.
Security guards.
My lord, first of all, my lord, the claim of the petitioner is regard to retrenchment. My lord may just, after perusing the act, my lord, he is a contractual employee, my lord. And the retrenchment cannot be
All right,
applicable.
if readings are complete,
Yes, my lord.
now we'll hear it.
My lord, there's an,
List for admission hearing
my lord.
on. We'll hear it for admission. 5th October.
My lord. Much obliged, my lord.
May I please your lordship? In this case, lordships, in the concerned Anganwadi center, there was initially one Anjali Malakar was appointed after following due procedure in the year 2009. Suddenly she expired. Then the respondent authority, without following due procedure, inducted the respondent number 6 against the vacant post of Anjali Malakar. I was a local candidate aspirant to apply for the same time to time requested for issuing advertisement, but they did not done. Accordingly, I challenged the appointment of the respondent number 6 by filing a title suit. Title suit was decreed. Set aside the appointment of the respondent number 6. Then I submitted a series of representatives to take steps, necessary steps for cancellation of appointment, but they did not do so. Subsequently,
No execution.
but there is no provision in the CPC lordship regarding such type of execution. In order 21, although 106 total provisions are there, lordship, but did not find regarding such type of execution relating to other way. That's why I have not filed any execution. And now the respondent authority cancelled the appointment of respondent number 6.
Hmm.
And my learned friend filed another declaration, that is next item, lordship 49.
What
This
about
also
the title appeal? Any title appeal?
Now title appeal is pending. My learned friend filed a title appeal before the court. Initially, title appeal was filed after 6 years, 2 months, 18 days.
Hmm.
That was dismissed on the point of delay. And
Then
subsequently, T-part second appeal, that is pending.
any interim order?
Pending. No interim order is there, only admitted.
Then
Then lordship, I approached the court to take necessary steps for issuance of advertisement to fill up the post regularly. Authority in the meantime already cancelled also. That is my submission. So humble prayer of the Indian state.
no, who is
Presently holding the phone number 6, the post.
respondent number 6, you are working in spite of an order of the setting aside.
Yes, lordship.
How is that possible?
Lordship, they have not filed any execution, lordship.
May not be, but there is a judgment.
Lordship, that was
So?
not executed after 7 or 8 years. They served an advocate notice, lordship. My preliminary objection is, lordship, writ petition is not maintainable for execution of the degree of a civil court, lordship. For that, alternative remedy is there, lordship.
What is that alternative remedy?
Lordship, order 21, lordship,
Hmm.
and
So what's the provision?
in RSA, lordship, already notice was issued. RSA were admitted also, your lordship. On interim prayer also, lordship, notice was issued.
Hmm.
And subsequently.
But there is no interim order.
Lordship.
Then?
That stay was not granted, but lordship, but subsequently, her service was, lordship, they have cancelled my appointment, so I have filed another writ petition, lordship. In that writ petition, lordship, notice was issued. And again, we have taken step, and in the second writ petition, lordship, the present petitioner has not appeared.
Yes.
My lord, since appointment in
What
terms
is your
of
prayer in the writ petition?
prayer in the petition to
fill up the vacant post by following due process of law. Lordship.
What is the due process of law?
Due process by advertisement,
Huh.
issuing advertisement,
So you follow it, you advertise it.
and already been cancelled. That is my prayer, Lordship. And second statement, page 37 is the impugn order, cancellation of our appointment.
Where is the, what about the second writ petition?
Lordship, notice was issued on
Hmm.
last occasion. It
Any
came
interim
before-
order there?
Lordship, stay was granted.
In the second writ petition
Yes, Lordship.
against
That is
termination?
2276, yeah, Lordship. That termination was stayed by this. court.
Then how can it be advertised?
Lorships. Now, finally,
That writ petition,
adjudicate the
Lordship,
matter.
he has not
Lordship.
appeared, Lordship.
Huh?
Matter may finally adjudicate now,
Finally,
if possible, time
we
permit.
will
Lordship.
post it for final hearing after
No,
disposal of the
otherwise
second
she-
appeal.
Otherwise, she will be illegally.
Have you filed any vacating petition here?
I am not praying for vacate.
In
I
that
am
petition,
praying,
Lordship,
Lordship,
he
that
has not
decide
appeared.
now. Because she continuously working since 2000
No, no,
13 Lordship.
who's continuously working?
private responder was she.
So you don't want to file a vacating petition? That's very kind of you.
Yes, that has to be.
But the question is, how does one
If
allow
Lordship
your
possible,
prayers?
Finally, may be decided.
Finally.
Not possible, Your Lordship, I am allowed to file vacation petition next week.
So we'll dismiss your petition.
The first ones.
First one will
Not
dismiss it.
required, Lordship, but because in terms of this already, second requisitions, Lordship, they have cancelled the appointment. That is my prayer. Already they have taken. into
You
consideration.
contest in that writ petition, this writ petition will close it. Your writ petition. Your writ petition is for what? To
To make
cancel
an
the
official
appointment.
advertisement.
That has been cancelled.
Appointment has also been cancelled.
Yes, but that is staying.
Advertisement part is still remain because of interim order.
Advertisement part will come only upon
Vacation,
the order being vacated.
Lordships. I am allowed to take that to file.
Huh?
I will file in the meantime.
In that case, Lordship, they had not filed wakalatnama,
In
Lordship.
the meantime, I will take instruction my client Lordships. Wakat number to be served to me.
You withdraw this writ petition.
First one.
Yes, that's
First one.
valid.
We'll give you liberty if you want.
Lordship, keep it pending. My submission is that since analogous matter is already been pending, the
No,
same
no.
time maybe finally.
Where is the
They are already
where
been
is the
considered.
connection?
Yes, Lordship. They are already been considered by the authority. In the meantime, I find Lordship. Because one part regarding advertisement, because there is an interim order.
Advertisement cannot be there so long the order is not vacated.
Yes, Lordship. So
You are yet to
keeping
get your
my-
instructions from your client to
Lordship.
appear in that matter and file appropriate
Lordship.
applications.
Short time may be given to me, keeping it pending.
Friday.
Next week.
You said short time, we gave you
Short-
Friday.
Short time, Friday, something for me, next week.
Next week, next Friday.
Oblige.
2020.
209.
List on 20.
Both the methods, Lordship.
09.
Lordship. I'm obliged.
Both the writ petitions.
Big loss. Well, in this case, might be very old case, might be 2013.
A rule
Well,
has
it-
been issued in this case, my lord, on 19/8/2013, my lord. What all pray, my lord, let this matter come up for hearing in the next week, my lord.
Why?
Page 65, kindly see.
Because, my lord,
Solvent matter already adjudicated by this honorable court lordship and decided, my lord, demanded their case setting aside the dismissal from service lordship and directed to my lord, impose my lord, case punishment lordship. Therefore,
Why have you not filed contempt?
My lord, contempt, my lord, subsequently appeal was filed lordship by
Ah.
the state, my lord, Union of India lordship, that appeal was dismissed, my lord. Thereafter, this page 65, this order was passed lordship.
Which order?
My lord, page 65,
65.
yes, lordship. I have challenged this order, lordship. My lord, annexure 7, lordship.
Yes.
My lord, page 66, I have challenged my lord, paragraph 8. my lord, trace. My lord, starts from paragraph 7, lordship.
So earlier you were dismissed.
Yes,
My earlier I was dismissed from service, lordship. The honorable court, my lord, found that
Set
the-
aside.
set aside, lordship, my lord, only one charge was, my lord, found to be established by this honorable court, lordship, that is misbehaved to the, my lord, superior officer, lordship.
Hmm,
And accordingly, that, my lord, order of dismissal was set aside, lordship,
hmm.
and directed to, my lord, pass order, my lord, punishment order within a month of within 3 months, lordship.
Whatever they have finally passed. They
Lordship.
passed this order.
First, this, I approached the, my lord, authorities, my lord, but they did not allow to join, did not pass any order, lordship. After 1 year, my lord, the appeal was filed, my
We are
lord,
not hearing a contempt matter.
my lord, contempt, my lord, did not, I am not on contempt, my lord. After 1 year, lordship, the appeal was filed, my lord, that was admitted, lord, subsequently, however, no, my lord, order of, my lord, stay was granted, lordship.
Very well. Now this order at page 66, para 8.
Yes, lord, 8,
This
lordship.
is the order passed, punishment order.
Punishment order, lordship, my lord, one
So
is.
what
my
is
lord,
wrong about it?
Yes, lordship.
What is wrong about it?
Wrong about, my lord, this is against the law, lordship.
Why?
I'm coming to that point. Can you see this, my lord? Reduction, subsequently another order was passed, lordship. My lord, that is why, may I read, lordship, reduction of pay of by 2 stages in time scale of pay in the revised pay scale of corresponding pay scale of rupees so and so for a period of 3 years with cumulative effect. Reduction of pay by 2 stages will be effective after fixation of his pay. He will not earn increments during the period of reduction, and that on expiry of this, the reduction will have the effect of postponing the future increments of pay. Now, my lord, absence period with effect from 27/4/2022 to 21/9/2012. Total 3804 days is hereby regularized, my lord. This is, my lord, all right. Now, my lord, next page 68. My lord, another order was passed, my lord. This is not order in conformity with the, my lord, the order of the disciplinary authority, lordship. My lord, last sentence, my lord. Hence, you are not paid any salary and bonus of above period. Sent for your information, lordship.
But you were not in service during that period.
My lord, I was not serving, my lord, but the honorable single judge, my lord, set aside that, my lord, order, lordship. Once the order was set aside, my lord, and directed to, my lord, pass order, lordship, for appropriate punishment, lordship. My lord, that dismissal order was not there, lordship. My lord, the authority, my lord, ought to have, my lord, allow me to join, my lord, immediately, lordship. I did not, I was not allowed to join, lordship. Thereafter, that period, lordship, this is not my fault, lord. I approached, lordship. Now, after, my lord, 1 year, my lord, in the writ appeal, my lord, kindly see the order.
Are you relying on any authority?
Sorry, lordship.
Any authority you're relying on?
No, lordship.
Why?
Now, honorable court, lordship, the division bench, my lord, while admitting the appeal, lordship, kindly see.
No,
Plus
these
56.
are not, these are irrelevant. Your case is that this has been altered
Yes,
pursuant to directions of the court.
yes,
Your period for 3,000 so and so days has been regularized.
yes.
Subsequently, another order has been passed holding you that you are not entitled to that
Yes,
period for salary and
Yes.
back wages, which according to you is not justified
yes,
because you were not in service because you were held to be dismissed, which was ultimately interfered with.
yes, lord.
Yes,
Now, my lord,
he has a point.
well, he has a point, my lord,
Yes.
the first order, my lord, which interfered with the that dismissal order, my lord. In that order, my lord, there was no order as such for his reinstatement, my lord. Only the quantum of sentence was to be reconsidered, my lord. And against that order, my lord, we went in appeal, my lord. And in
That
appeal,
was
my
the
lord,
appeal was dismissed.
my lord, yes, appeal was dismissed. Immediately after, my lord, we reinstated back in service. Then, my lord, this order was passed. The impeachment order was passed after that. On 4th of October, my lord.
What was the
2012.
direction of the court? Writ court?
my lord, the read court's reaction is, my lord, at page 49, that is the judgment. Page 41, my lord, the abortive portion as it has directions and findings are page 54. My lord, paragraph 11. Married lordship. In the present case, charge number 3 partly and charge number 4 essentially deals with the causing of death of head constable Saidullah Khan by the petitioner by firing from his service weapon. On the same facts, the petitioner was tried on a charge under section 302 IPC. The petitioner had set up a plea of self-defense, which was the same plea that was taken in the departmental proceeding. In the criminal trial, which was closed subsequently, the plea set up by the.
All right,
but-
we'll take it up for hearing on Thursday.
My lord.
For hearing on Thursday.
My lord, even then, my lord, the section 72, my lord says, my lord, no, my lord, stoppage of increments cannot be, my lord, more than 1 year. Lord. So it is.
But again, my lord, the procedure prescribed for punishment is rule 22, no, 27. He's quoting section, actually,
is that-
this is not act, this is the
We'll
rule.
take it
my
up
lord.
on Thursday.
Yes, my lord.
This is just misbehavior.
14th.
This is major punishment. Oblige, lordship.
All right.
Regarding the contempt lordship, on the other day, directing my senior counsel to take instruction as to the compliance of the order. Taken 19.
Yes, Mr. Ahmed.
Yes.
You will find the order at page 10, authority portion at page, paragraph 6, at page 11.
Yes, Mr. Ahmed.
Page 12, your lordship will
Para 7.
7. In that view, the matter is supported of the considered opinion that the impugned letter dated 2/1/17 is vitiated and the same is accordingly set aside. End quote. The respondents are directed to consider the case of the petitioner for dependent employment, compassionate employment against the next immediate vacancy that arises in future. It's very simple. Your lordship, this is not a post which is of a regular nature. It's a dependent employment is under a scheme.
We are examining a contempt matter.
That's true, your lordship.
So
And there's no next vacancy here, your lordship, that interpretation would be wrong. Because the 3 persons who were appointed, as shown by my learned friend, they got those appointments as dependent employees based on the scheme. Nobody else can be appointed there.
If your lordship takes up my original agreement, that is the language used by the, while rejecting my.
what is the post that his father was working?
Mazdoor.
Labor.
Labor. So the direction of the court is that that labor, it's not a regular post.
Not really. Labor in their case is only on the basis of the scheme of Coal India.
So
And there's
in the
natural-
face of this order, you have to decide what you want to do.
Your lordship, there's no vacancy that way
No.
where we can appoint
No,
him
no, no.
immediately.
The-
I cannot appoint him against the 3 posts that were.
The court proceeded
Yeah.
on the facts that his father died and you are required to make an appointment, consider his claim for compassionate appointment and make it. Now, while doing so, the court directed that the letter rejecting the petitioner's case for dependent employment
We consider,
be reconsidered.
and we've done that. We passed an order.
No, the reconsideration has to be done against the next immediate vacancy that arises in the future.
Next immediate vacancy, now that is where your lordship will have to interpret whether that next vacancy.
We can't interpret.
Your lordship,
Contempt matter.
Why should we
How can it
interpret?
be- How can the petitioner?
If
be
you
appointed?
if you require clarification in this order, you know your remedies in law. So far as this direction is concerned, it is very categorical. You have to consider his case in against any vacancy that arises in future.
Yes, against that, your lordship, we filed a representation. We have disposed of that. representation.
You are disposed of by saying that it cannot be considered because he is against a Mazdoor. His father was a Mazdoor. That will not be consideration in
There's
terms
no-
of the directions of para 7.
There's no vacancy. There has to be a vacancy.
Therefore, we can't give you legal advice what you should do, but this order 7, para 7 in the order has a very categorical direction
That
for you to
clarification-
consider against immediate vacancy that arises in future.
Lordship, that interpretation of immediate vacancy cannot be in place of the three who were appointed.
You show us any authority that while exercising a contempt jurisdiction, we now rehear the matter.
No.
This will amount to rehearing the matter.
Not rehearing matter, your lordship.
Pass the order and. Pass the order.
We have, as per our order,
That will be page 38 of the new.
at page 38, your lordship will see the last paragraph.
It should be from para 2, it should be page 37.
It is there from 37. I'm reading the last paragraph,
Page
38 of our.
My edition, they are different.
38 of
The additional affidavit
By the 18/7/2000.
that was filed on 18/7 to 22.
That is an order.
additional affidavit filed by,
By me lordship.
what is your name?
Kudugu Ramesh. Was filed on 18th of. It was filed on 30th of June, lordship 2023.
Yes. Page 38.
38 of. His lordship was- The affidavit dated 18/7/23.
Yes.
Lordship will take it up on page 37 itself.
Hmm.
Pursuant to the order of this honorable court. Which is dated
35/23. 35/23.
effect which is none.
Order. 35/23.
The order person. The order person. May I read it?
Yes.
Yeah, above noted case whereby you have expressed your grievance for not having been granted compassionate appointment and have averred that we are liable to be punished for contempt of court for not complying with the direction of the Honorable Guwahati High Court on the above subject matter, came up for consideration before Honorable Mr. Justice S. Shyam of the Honorable Guwahati High Court on 3/5/2023. And the Honorable High Court directed us to dispose of your claim for compassionate appointment within 3 weeks from the date of the said order. This is after the order that your lordship was looking into.
Your interpretation, I will not be able to accept. Let me be very candid about it. The order of the court is to be read for what it is. It doesn't call for any interpretation.
No. After
So
that
this
order, your lordship.
order of the court is, you will consider his case against the next immediate vacancy that arises in future.
That is.
And your letter, your reasoning at page 38 says, no vacancy arises in the category of dependent employment or compassion. We do not know what vacancy in which category. That is not specified in the order. Order of the court is that it has to be considered against the next immediate vacancy.
And that's true. After that, this Honorable Court passed this order dated 3/5.
Where is that order?
Is there in your lordship in this record?
Huh?
Is there in the record?
3/5.
Yes, 3/5/23.
Yes.
The Honorable.
Yes, okay. You are harping on the aspect of consideration, but consideration will have to be in terms of the directions of the court. So long it
No.
stands.
True. We have clarified that next vacancy doesn't come automatically.
What are these dependent employment and compassionate employment? What is the category of these
This is
employees?
under National Coal Wage Agreement Scheme.
It's a page 5.
We have quoted that provision 9.5 at page 5.
This is not covered, this does not cover the workers.
Which one?
The petitioner's father is not covered by that.
Petitioner's father was covered, but his case was rejected because of delay. Various other reasons, delay also was there. Within 6 months, application has to be made
Application to be?
for dependent employment. That was.
I'm sorry,
rejected
I'm not following. Application is to be filed by whom?
By the.
By the person concerned.
Yes.
Before whom?
Before us, before the authority
Ah.
of Coal India.
Ah,
The file, it was delayed, it was beyond 6 months. In fact, now this is 10 years.
hmm. No, but the order of the court remains. You have not done anything about it. So,
Now, after that order, this 3/5 order came.
no. If it is a case that your vacancies in the under Coal India are vacancies which arise in other categories to
Only,
which the petitioner does not have the requisite qualification, we can understand it is not capable of being implemented. That is not your case.
no, how case is that he may have been eligible after his father's death to be appointed.
But there was a delay.
Great delay.
So all these things are deemed to have been considered by the court.
But again, that next vacancy does not say that it has to be a vacancy that may arise. It could be the vacancy of general manager also.
No, that's what I'm,
Nothing clarified by the
No,
court
no.
also.
see, that is the query of the court. That in case you say that, yes, we considered him in respect of the vacancies, immediate vacancies available, but none of these vacancies,
No,
he is
this-
eligible because he does not have the requisite qualifications.
No, it's not a question of vacancies. It's a question of, these vacancies arise only upon the death of an employee.
No, we can't clarify this order. We can't clarify this order. This
again-
order is very, very categorical.
Against that, your worship, he filed a representation before us. And
Then we'll have to
Then-
hold that this consideration is not in terms of this. We'll have to issue notice in contempt, whoever the person is.
Yes, Lordship, that will be better, Lord.
No, it's
We'll-
okay.
We'll
I
have
have-
to,
I have
we'll
no
have to
problem.
hold that this order that, this representation that you, this order that you have passed is not in terms of the directions of the court.
Your worship, we have considered that direction after his subsequent representation. And that is where we are giving the response. Where Mr. Honorable Justice Shyam had
Page number?
said at page 37.
Your
Uh-huh.
representation was filed by me, Lordship. And if your Lordship kindly see the language at paragraph 2 at page 37, this itself implies that there is a legal problem of these contaminants. And therefore, they are liable to be personally present before this honorable court to explain.
It is all right. He may make his allegations if it helps him.
Because that
I'll
word that I
repeat
have,
it.
I have rushed I filed hurriedly the contempt petition. 5 months I have waited. Who orders were passed by this honorable court?
Not two orders. There's only one order. Don't mislead people.
No, in 2016 there was an order. In 2018 also there was an.
We are now on.
Mr. Ahmed,
I have an act in the report.
you have to, we had given you time to reflect, but apparently you are trying to interpret a court's order, which we can't permit. It doesn't call for any interpretation.
Your Lordship, that case. My submission, there is no contempt, but we have disposed.
We'll
of this
record your
representation.
submissions, we'll record your submissions, but
But your Lordship will give me time for further reflection. I'll consider with management also what they have to say. Within a month, we'll give a response.
the 1 month is, this order has already been, when was this order passed?
Earlier order was passed on Lordship 1/8/2016. Thereafter, I have to file again another petition which was disposed on it filed on 2017 and disposed of on 19 to 2018.
2018 matter. This
2018.
contempt is against which order?
Against that
18 order.
883, 2017. In my, if your Lordship.
We are giving you a final opportunity, you dwell over it. Your attempt to interpret this cannot be accepted. The order of the court can't be interpreted. We'll have to read it for what it says. We'll have to read it for what it says. Your reply doesn't say that the vacancies which have arisen, he's not qualified. He doesn't have the qualification, etc. Nothing like that.
Now, if your Lordship comes, page 35 of my additional affidavit, this is the order issued on 31/5/2023 appointing to
Mr.
Thapa.
Ahmed is senior counsel is permitted further time to complete his instructions in the matter as regards the steps taken to comply with the directions of this court by the judgment and order dated 19/2/2018 passed in WPC number 883 of 2017. Stop. Mr. Ahmed submits that he will address the court on the steps taken for compliance of this order. Mr. Dhar appears for the petitioner.
In
I will request you to reflect on the order.
if the authorities do not comply with the order passed by this law, personal appearance may be.
We will pass whatever orders are necessary. That you leave it to the court.
Right.
List after 2 weeks,
Lordship, the date may be fixed, sir.
3 weeks, Your Worship.
3 weeks, all right,
Date may be fixed, sir.
3 weeks, give it.
In contempt case, there cannot be an interpretation, Lordship. There.
Can it be 4th of October?
4th October, all right. 4th October. All right, 4th October.
Bishop.
Yes,
My lord, I'm just placing a written instruction before Lordship. It's a small note. The proposal was submitted by the executive engineer PW Dhubri. So my lord, basically PWD, the department and has proposed his name. It was placed before the DLC. DLC has rejected, my lord, on the economic criteria. Now, my lord, I will come to the last page of the writ petition, my lord. So it was considered, my lord, and on the economic front, my lord, criteria, it was rejected. And private respondent was given the job, my lord. Now, my lord, my senior colleague was referring to this vacancy position in the last page, my lord. Vacancy position in the right-hand side column, my lord. Vacancy position year-wise, both grade 3 and grade 4, shown separately for grade 3 and grade 4. So, my lord, for grade 4, 2012-13, 2 posts.
where are the minutes of the DLC?
My lord, it is page number 24. Our operative part, my lord, that executive engineer PW Ruel Dhubri.
Yes.
Year-wise vacancy under the jurisdiction of executive engineer Ruel division. Vacancy 2 posts, 12-13. So, my lord, basically there are 2 posts.
We have 2 posts in grade 4.
Grade 4, meaning thereby, my lord, this is not for compassion appointment, my lord. This is, my lord, overall 2 posts. So, my lord, if you go by 2009 OM, that is 5%. Here also, I would say that yes, even the department should not have gone for this also one post that they have carved out of these 2. Because 5% is the total. At least we need 20 vacant posts to carve out 1 post for compassionate appointment, my lord. That is 5%. If you go by the OM of 2009, that is followed again by 2015. So, my lord, here we had only 2 posts. From that one, this is, my lord, regular vacancy. This is not earmarked for compassionate appointment, my lord. So, my lord, here we find in the last page.
Then
Yeah.
why have you considered the financial position?
That my lord,
Then why the who were appointed here?
private respondent, my lord.
Then
My lord, I don't know under what circumstances one post was carved out, but that is not challenge. That is not the, my lord, subject of challenge in this writ petition. His case is that, my lord, he should have been considered. We said we have considered, and because he had a better economic criteria, so that is what, my lord, the OIM says so. The economic condition of the candidates will be evaluated, and my lord, who will have a better position, who will have a less chance to get into the appointment, my lord. That is always there, my lord. So out of this, these two is, my lord, this is overall position vacancy, 2 vacancies. We cannot have 100%, my lord, this allocation for this competition appointment, my lord.
Yes.
What he is submitting, Lordship, I have already placed. Kindly see page 13. What he is submitting, that is not correct. The format for submission of particular aspect of applicant applied for appointment on compassionate ground. The Lordship, they have stated grade 3 post 3, page 13. Let them file an affidavit to the effect that only 5% of the vacancy of that period, Lordship. This is a new stand taken by the department.
All right, that is one area. What about the financial criteria?
Financial criteria, Lordship, will kindly see the financial criteria. What is the financial criteria? Page 28. 2 post financial criteria, Lordship, will find. That is, Lordship, the debt benefit given to the employees, other. DRGS 2,80,000, leave salary, and Lordship, the GIS total 4,80,000. My is 5,31,000. That is economic criteria, Lordship.
Exactly, my lord. That is what, my lord. If he has 1 rupees more even, he will have in a better footing. So the private respondent at 480, 4,80,000, 425, whereas he got 5,31. We had to, my lord, choose between these two. So he is in the writ petitioner is in a better financial position, my lord. We go by the numbers, my lord.
So the criteria, you're better off financially.
Better of, Lordship, they have appointed the person not on considering this position, Lordship. Now saying the economic criteria, that is also only, Lordship, around 50,000 benefit given by to the father after his death. That has been considered as a criteria.
How else is the criteria to be determined?
Let them file an affidavit to the effect, Lordship, regarding this
You
criteria,
tell
Lordship.
us how the criteria.
They have not
criteria-
filed an affidavit. Now they are submitting. We have challenged this procedure because vacancy position was true and one has been.
All right,
recommended.
file your affidavits. Third learned counsel, Mr. Or will file the affidavit on behalf of the department. List after 3 weeks.
Then I can give the reply, Lordship. I can give the reply, Lordship.
After 3 weeks.
My lord.
Short date may be given, Lordship. It is long pending, Lordship. 2 weeks. They have got the instruction.
It's long pending, therefore we are giving them an additional 1 week. So that beyond that, no further time,
Applies.
after 3 weeks. Yes. Yes, itu ada itu mana? 42. Yes, 42.
In this matter, we have no instruction from the petitioner, Lordship. Kindly fix this matter after 1 week, Lordship. We are unable to contact the petitioner, Lordship.
Mr. So-and-so learned counsel for the petitioner submits that he is unable to contact. Requires 1 week's further time to obtain, complete his instructions. MS Sharma,
P. Sharma.
P. Sharma appears for the respondent list,
3 and 4.
list after 1 week. Much obliged.
Obliged. Lordship, though late, but some positive steps has been taken by the authority, Lordship.
Complied,
taking-
not complied.
Totally could not comply, Lordship. It is going to be, Lordship. They have taking process for approval for finance, approval from finance.
You and I will read you.
Lordship, few time may be granted to come up with some positive result, Lordship.
You show it to the finance.
Hi, party, no, no.
No, there may not be a party, but you have referred it to the finance, put him to notice also. Heard learned counsels for the parties, MS RB Bora learned counsel appearing for respondents.
Respondent number 3.
3. Submits that steps are being taken to comply with the order. However, some further time is necessary as the matter has been forwarded to the finance department for necessary approval.
But Lordship, respondent number 3 is no longer principal secretary of BTC now, Lordship.
Whatever, it is for them to decide. Matter will be listed after 3 weeks.
Deeply,
Copy of the instructions is retained in the case record.
deeply.
Lordship, this is a review petition filed by the department, Lordship,
Yes.
for reviewing the order dated 21/9/2015, passing WPC number 3894/2014, Lordship. Now, in this case, Lordship, notice has already been issued. And today matter is listed in the order column, Lordship. So if they are not filing, Lordship, any affidavit with or reply, Lordship, then Lordship may fix this matter for hearing, Lordship.
Review, anything you want to say?
They have filed a review petition for. Fact is that their order has been passed by this court. To giving directed to a petitioner to be regularized. And thereafter they have not regularized the petitioner. Thereafter a contempt petition has been filed. After contempt petition, when the contempt petition going on, the court itself says that you have to comply the matter, there is a remedy. If you not comply the matter, remedy is elsewhere. And therefore they filed this review petition after delay of 7 years. This review petition filed after 7 years. The judgment was passed on 21/9/2015. And direction to comply, the contempt petition was filed on 24/10/16.
You are working as what?
Workshop.
Yeah.
Workshop.
Work charge.
Yeah.
Now you want to be regularized.
Yes. And my submission is
Is that division bench judgment coming in the way?
No, otherwise also, Lordship, their workshops employed, they are otherwise also getting scale pay, Lordship. So even if.
But they are not regularized.
They're not regular.
Your claim is for regularization.
Yes. The court, my judgment was 2015. 2015. And at that relevant point, the judgment, what is even the court has passed a very reasonable, very detailed
Where is the
judgment.
Upendas judgment?
Very detailed
Pendas
judgment.
Lordship came in 2017. Lordship, here, your Lordship will see one notification is there at page.
Very detailed judgment,
103.
considering the all judgment at that relevant point of time. And after that, court and come to a finding that I am considering the all documents. And thereafter, what they in review petition they say, thereafter another judgment is coming from a works of Lordship, is correct, the division bench. But my submission is that
This is in 2017.
And their judgment will not affect us. Lordship is not this constitutional judgment in Aadhaar case. What the court specifically said that change of in-law subsequent decision or judgment of coordinate bench or larger bench itself cannot be done for review. The order which has been passed, this is settled law, the order which has been passed is binding to the parties. That ground, they cannot take in the review petition. The review petition, what I am, after going to the review petition, at the time of what you kind of picked up hearing, I will put at the document who they had the ground. I will show you, Lordship, that every ground which had taken by them is considered by the learned single judge. And therefore, the honorable court in contempt petition, they have specifically said that you have nothing to do. Your remedy is elsewhere, not in review.
All
They
right.
can file in the appeal. They may file in the appeal. That is
This-
different aspect of law.
After hearing learned counsels for the parties, matter be listed for hearing. We'll hear it then.
No, it comes from the admission, then it is not admitted. Admission that they will hearing their lordship will first fix it. We will completely because only to decide as per
List for hearing on 20.
Lordship, if they are, Lordship will record that they are not filing any reply, Lordship.
not a review petition.
It's okay.
As the learned counsel for the respondents does not wish to file any
No.
objection.
The record, on the basis of the record, we will argue because.
Do you
Yes,
want,
yes.
we are recording it,
Yes.
that you don't want to file it.
We will file it, if required, we will file it.
We don't require it. If you want to file it, you file it.
Because it is a review petition yet to admit it.
What is the, where is the question of admitting it? We have
No,
to
we'll-
hear it, whether it's a review lies or not, does not lie. Or at least after, how much time would you require? 2 weeks.
What do you mean? Fine.
After 3 weeks, enabling the respondents to file their response to the review petition. File, list after 3 weeks. Listed after 3 weeks.
Of that.
Yes, have you filed? Amended course title?
Yes, my lord. And first title also amended, Lordship.
Now you have to take steps
Lordship,
on the newly implemented.
Lordship, Lordship may issue notice, then I may take step, Lordship.
Heard learned counsel for the
Lordship,
petitioner,
Lordship, before passing
person to the,
before passing the order, Lordship, I may submit, Lordship, that respondent number 1, Lordship, is directed to comply the order, Lordship, mainly.
he's
Respondent number 1 is liable to
comply.
comply the order, Lordship. But Lordship, respondent number 1 has no response. More than, Lordship, several times, Lordship, 3-4 times. Prayed for time to file. If you Lordship, till that is not filed.
No, let us issue notice on the newly implemented.
Lordship, that may be, Lordship,
Newly implemented persons will have to be issued notice.
yes, Lordship. But
Pursuant to
similarly,
the order dated 16/8/2023. The director, Sri Narayan Kaur, IAS Secretary to the Government Education Secondary Department, and Srimati Mamta Hojai, AES Director Secondary Education Assam, are arrayed as party respondents 4 and 5 in
Lordship,
contempt petition.
Lordship, may I please, Lordship, I will 6, Lordship.
It's written here 4 and 5.
Lordship, in the IA, Lordship, it is rightly. Lordship.
Stop upon. Where is the course title that you have filed?
It
Amended course title?
it should be there, Lordship. I have a copy, Lordship.
Are arrayed as respondents 5 and 6 in the contempt petition. So accordingly, let notice be issued to the newly implemented respondents by registered post AD. steps within 1 week from today. List after 4 weeks.
The date may be picked. Lordship.
You take steps, you have to take steps.
Respondent number one is Lordship, he is not responding, Lordship.
We'll see about that. Let it come after 4 weeks. You renew your prayer
Okay.
after 4 weeks.
Number 51.
Even on the last petition also, my lord, the petitioner did not appear.
What order has been complied with?
My lord, in fact, my lord, the writ petition was disposed of as infructuous, my lord, there was no direction. And even after.
Where is the order?
My lord, page 30, my lord. Page 30,
30.
30, my lord. During the pendency of the writ petition, we have considered the case, my lord, we filed the affidavits. The other side.
Why the
received-
contempt has been filed?
My lord,
Why the contempt has been filed?
that is what, my lord, we also don't know, my lord, that because perhaps no contempt lies, my lord, because the order was, there is no direction. The writ petition was closed as infructuous, my lord, page 30, my lord, we see. In view of the submissions and the documents mentioned, the writ petition is closed as infructuous.
Have you made this pay? Have you released the amount?
Yes, my lord, all, everything has been released.
Yeah.
My lord, we have cross-verified the case, my lord, all the amount has been released, my lord. Page 2, my lord, may peruse.
None appears for the petitioner uncalled. On 1/9/2023 also none had appeared. Then the matter was called up. Stop. Para. No. Mr. H. Gupta appears for the, before para, Mr. H. Gupta appears for the respondents. Para. This contempt petition is filed with the petitioner alleging willful disobedience of the order dated 3/2/2021 passed in WPC number 7838 of 2019. By the said order, the following directions were passed. Quote the entire order, page 30. Stop. Para. Today, when the matter is called up, Mr. Gupta, learned CGC appearing for the respondent, submits that the amounts of rupees 91,821, 55,078 and rupees 316,586. What is the name of the petitioner?
My lord, Imtaz Ali, my lord.
Has been released in respect of the petitioner. Stop. Mr. Gupta has placed before this court communications to that effect received from the respondents. Stop. Upon due perusal of the communications received, it is seen that by order dated 3/2/2021, passed in WPC so and so, the writ petition was closed as infructuous on the statements made by the learned counsel appearing for the respondents in the present contempt petition, that the revised pension has been finalized and PPO, pension payment orders of the petitioners have already been issued for payment of their pension. Stop. That apart, by communication dated 13 July 2022, copies of which are furnished before the court. The said communication encloses documents relating to release of pay fixation / MSCP area in respect of the petitioner to for an amount of rupees 55,078. And the said amount has been shown to be credited to the bank account of the petitioner. So in that view of the matter, the order dated so and so stands complied. Therefore, no further cause arises in the contempt petition to proceed against the respondents. The contempt petition accordingly stands closed. Notices issued are recalled. Disposed. Yes.
And these clients have altered their view. This letter, specific letter, skip their view, their notice. So they are now, we have advised them to send a fresh proposal to upgrade this fellow, this petitioner to grade 3. Lordship, I would require some more time to mandate compliance of this.
Lordship, he undertakes that they're going to process, Lordship, it's fine. Lordship.
And in case, Lordship,
Learned counsels for the parties. This matter was fixed today for taking up the interim application filed by the applicant seeking dispensation seeking orders for dispensing of their personal appearances. Stop. On 8/9/2023, the matter was deferred till today, enabling the respondent counsel to complete his instructions. Stop. Today, when the matter is called up, learned counsel appearing for the Forest Department submits that. What do you want to submit?
This
Letter.
It will be withdrawn. That's not the press.
Where is that letter?
This 14.
Page 11.
Oh, that is not-
11.
the view of this letter.
That in view of the letter number so and so dated 16 June 1998, which is available at page 11, whereby the case of the petitioner was recommended against a grade 3 post on compassionate grounds subject to availability of vacancy, the respondent authorities by oversight did not consider this aspect of the matter, therefore seeks liberty of the court to now proceed in the matter accordingly and pass appropriate orders. Mr. Gogoi, learned counsel for the petitioner, for the respondent, and the applicant submits that some further time be granted in enabling the petition, the respondents to comply with the orders of this court. Why the order dated so and so, passed in WPC so and so. In that view of the matter stands deferred for 3 weeks.
IABL.
In that view of the matter, the personal appearance directed by the court is not considered, is dispensed with for the time being,
For a time, yes, Lord. That's what is it.
for the time being. In
For
that
time,
view of the
Lord.
matter, the I stands closed. Matter will now be listed for orders
Fixing it, that's okay.
after 3 weeks. Copy of the orders passed in the IA be retained in the contempt petition. List after 3 weeks.
Date
Give
of-
it.
4th October. Lordship. Oblige, Lord.